Hello, everyone, and welcome. I'm Elizabeth Wydra, President of the Constitutional Accountability Center. I'm delighted that you could join us for our 7th annual Homestretch at the Supreme Court event. This is the day in which we come together. Usually it's the last day after oral argument, as it is today, of this particular term, and look at the big rulings that have come down already, the perhaps even bigger rulings yet to come, and just talk generally about the themes that we see in the court's term this year, how the justices are doing, and any tea leaf reading for the future. Now, obviously, things are different this year. I'm coming to you from my home, as are the rest of our panelists coming from their home, instead of our usual spot in the National Press Club here in Washington, D.C. The coronavirus pandemic has put us all to the test, some more severely than others, but to everyone, I just want to say that I appreciate you joining us today, and I hope that you and your families are able to continue to stay safe and healthy and sane as possible in these trying times. As someone who's always an optimist, I try to find silver linings in any situation, and one of the silver linings that we can see today by having to do this event virtually is that we are able to be joined by a panel of experts on both coasts, amazing scholars and practitioners, and I'm very grateful that they could join us today to talk about this momentous Supreme Court term, momentous for many reasons. And another one of those reasons that it is a historic term is what I would say is another silver lining from this situation. As the Supreme Court had to close its physical doors to the public and to even those advocates who would come and argue before it, they have started doing telephonic arguments, including live audio broadcasts. So the American people now can tune in and hear the justices and the advocates wrestle with these weighty issues. This is something that I think over these past 2 weeks has been an enormous success, putting aside the flush heard around the world and a few unmuting accidents here or there. But it has really, I think, been a great proof of the experiment that having live audio is only to the good, both for the court and for the public who are affected by the court's decisions, including my dogs, who apparently have lots of views on this. And I just want to say that just as the rest of us have figured out how to do our work at home with children and dogs and all sorts of other distractions, it's really a blessing that the Supreme Court has also found a way to do its job during these times. Because the cases that are before the court are of the utmost importance to the daily lives of all of us who live in this country, and perhaps now more than ever. Now we are going to be impacted by cases that address whether LGBTQ Americans can continue to get their much needed paychecks and not risk getting fired for who they are or who they love, whether people who need abortions can access that crucial healthcare treatment, whether people who have known this country as their home their entire lives, dreamers, can continue to get the protections of the DACA program. In addition, of course, to major issues affecting our democracy itself, whether Congress and other investigating bodies can continue to do their important work of oversight, which in these particular cases before the court deal with President Trump's financial records and tax returns, but also impact broader issues of oversight that will be necessary as we fight this public health crisis and whatever ones are to come, in addition to whether corporate watchdogs can continue to effectively fulfill their mandate. So given these important issues that affect us in this court's docket, I'm thrilled that we have this panel of experts that will be moderated by the fabulous Kimberly Atkins of WBUR, who will be moderating the panel, again, as I mentioned, of wonderful experts from coast to coast, featuring CAC's Chief Counsel Brianne Gorod, Stanford's Pamela Karlan, NYU's Melissa Murray, and of course, our tireless immigration advocate, Karen Tumlin. So thank you again for joining us, and I'm delighted now to turn it over to Kimberly.
Thank you so much, Elizabeth. I'm delighted to be here. Thank you so much. And thanks to all of our participants as well as our panelists. Before I kick off our discussion, I just want to let you know we will save some time at the end of the program to take some questions from the press and from our other participants. So you can pass those along the way in the comment section, and we will get to as many of those later as we can. So first, to kick off our discussion about the cases on this term's docket, I would like to start with Melissa Murray, who will take us through the challenge to the Louisiana Unsafe Abortion Protection Act, which was heard earlier this term. Hi there, Melissa.
Hi there, Kimberly. Thanks so much for having me and for moderating this, and many thanks to the Constitutional Accountability Center for doing this. June Medical Services is one of the most hotly anticipated cases of this term for a lot of different reasons, certainly because it involves questions of abortion restrictions, but also because it involves the question of fidelity to precedent. June Services follows closely on the heels of Whole Women's Health, which was just decided in 2016, adding some teeth to the standard the court announced in 1992 in Planned Parenthood versus Casey. And so the questions in June Medical Services seem very similar to those in Whole Women's Health. And if you are having a strong sense of deja vu, you would not be the only one, because the admitting privileges law that's being challenged in June Medical Services is the virtual twin of the admitting privileges law that was struck down in Whole Women's Health versus Hellerstedt. And so the question before the court are really two important questions. One that the court added itself, and that's a procedural question regarding standing. And that question is specifically whether the providers are the appropriate parties to bring this challenge on behalf of their patients. And the fact that this standing question was introduced into the mix by the court is actually quite significant because, of course, for many years, providers have been the ones to challenge abortion restrictions on behalf of their patients, and it hasn't really been a question, this question of third-party standing. Justice Thomas, in his dissent from Whole Women's Health versus Hellerstedt, noted that he thought was a constitutional incongruity to have the providers who were not necessarily the persons whose interests were at stake to bring these cases. And he raised that issue, but he wasn't joined by any other justice. But nonetheless, that argument, which seemed a little far-fetched in 2016, has gained some traction since then. And the court introduced that question, that procedural question of standing, into the mix for this case. So before the court can even get to the merits in June Medical Services, it must first decide whether the physicians here are in the best position to bring these claims on behalf of their patients. The merits question, of course, is whether the admitting privileges law that Louisiana passed in 2014 is an undue burden on the right of women to terminate their pregnancies. And the Fifth Circuit, in reviewing this case, had June Medical Service or had Whole Women's Health in view, but determined that the facts presented in the Louisiana case were markedly different from those presented in Texas. So they distinguished this case from Whole Women's Health on the factual record below. And at oral argument, that really was a lot of the action between the advocates and the court. Julie Reckelman, who argued this case for the Center for Reproductive Rights, argued that there is no health benefit to women in this law. And Louisiana has basically promulgated this law in the interest of promoting women's health by making sure that abortion providers are properly credentialed and have the option of admitting their patients to nearby hospitals in the case of things going wrong. As Julie Reckelman said, the fact that these admitting privileges are rarely used by abortion providers seem to have been of no moment to the Louisiana legislature. And in fact, it has no bearing on any medical benefits that women can actually glean from this law. And so instead, she focused primarily on the burdens. And there was a lot of pushback from both Chief Justice Roberts and Justice Kavanaugh on whether or not this benefits and burdens analysis could be done in a straightforward way, or whether it actually had to be a state-by-state, case-specific analysis. And Julie Reckelman continued to press the idea that without any true medical benefits to patients, the burdens were more obvious than the benefits were, and that this would clearly fall under the standard enunciated in Whole Women's Health. Her opponent, Elizabeth Reckelman, who's the Solicitor General of Louisiana, continued to press the idea that there is something different about the situation in Louisiana, and that these laws in Louisiana really are used as a credentialing mechanism for all physicians and specifically abortion providers, and that there is no desire to burden abortion access. Although she didn't have a terrific answer for the fact that if this law were to have gone into effect, it would really reduce the number of abortion providers in Louisiana substantially, leaving only one clinic in the state. And then finally, there was Jeffrey Wall, who was arguing on behalf of the Solicitor General's office in favor of Louisiana's position. And he too seemed hard-pressed to explain how this law would actually have benefits that would outweigh the substantial burdens on access that would be presented were it to go into effect. And so the case is really closely watched. It's a really important case. The standing issue, if the court determines that the providers are not the appropriate parties to bring this case, would have significant consequences for the future of abortion litigation. And of course, if the court did reach the merits, that of course would have strong implications for what other states might do in terms of restricting abortion and limiting abortion access.
Melissa, a question that I get a lot with respect to any abortion case that's before the court is does the court seem to be taking aim at Roe v. Wade? Will it be a chipping away of the protections of Roe and Casey and other cases, or might we see an opportunity to revisit Roe v. Wade altogether? Is there anything that came out of this case that could give some indication of where the court is heading in the big picture?
So this case doesn't necessarily present a frontal challenge to Roe versus Wade. So this seems to follow on the more incremental approach of simply chipping away at abortion access, such that the right to an abortion is basically a nullity for many women across the United States. But of course, there are a number of cases percolating at the lower federal courts in the wake of a rash of more aggressive and provocative legislation that's been passed in the last 2 years that really are aimed at a frontal challenge to Roe. And so I think the real risk here is not that Roe is felled. I don't think it's likely that Roe is going to be overturned with this case, but the fact that Roe survives after this case might lull some into thinking that the worst of this is past, when in fact, the chipping away of abortion access is quite significant in terms of access to this right. And there is a looming challenge to Roe just coming down the pike, I think.
And the biggest change since the last time we've seen a lot of abortion litigation on the court is the makeup of the court itself. Most recently, the addition of Brett Kavanaugh to the bench last year. What do you think? What impact do you think that's going to have here?
So this is a big question. It's not just the impact of Brett Kavanaugh, but also Justice Gorsuch is on the bench too, and he was not there in 2016 when Whole Women's Health was decided. And the bigger question, of course, is not just the addition of these two new justices, but the absence of Justice Kennedy, who was not always a stalwart supporter of abortion rights, but could be counted on in some cases to sort of go with the liberals on these questions. The addition of Justice Kavanaugh is a really interesting one. He replaces Justice Kennedy, but he seems to be a little bit more to the right on some of these issues. There was a stay that was issued earlier in this case prior to the grant of certiorari, in which the challengers asked for the law to be enjoined and not go into effect while they waited for the court to determine that cert petition. And the Chief Justice actually came on side with the 4 liberal justices to grant that stay, and Justice Kavanaugh dissented. I'm preferring instead to actually have the law go into effect so that you could make a factual determination about the limits on access that would flow from it.
Okay, well, thank you so much for that introduction to that case. And if the audience has questions, we're going to get to some of those later on in the program. And now I'm going to turn it over to Karen Tumlin, who is going to give us an introduction to another big case on the docket this term. That is the challenge to DACA, the order put in place in the Obama administration that was rescinded by the Trump administration. Hi, Karen.
Hi, Kimberly. Thanks so much for facilitating this conversation. It's lovely to be with all of you and all of you virtually. So I'd like to say a little bit just to scene set the DACA case. And so for folks who are not as familiar, DACA, or the Deferred Action for Childhood Arrivals program, is a program that's almost 8 years old, was created by the Obama administration. And it did basically 2 things for immigrant young people who came to this country as children and graduated from our high schools and colleges. It gave them critically permission to work with federal work authorization, and also the ability to apply for temporary protection from deportation or removal, really eliminating the fear and the specter of being deported from the country for 2-year increments. And so the issues before the court are rather simple. When President Trump, not when he came into office critically, but nearly 9 months after being in office and after continuing the DACA program, he terminated the program. His administration terminated the program. And they did so saying essentially that their hands were tied and that they had to end the program because it was unlawful. Now, query whether, if you believed the program was unlawful, you would have continued it and issued both new DACA grants as well as renewals for nearly 9 months. And the questions before the court are twofold. First, can the court even review this at all? Is it justicable such that the court can have judicial review over a new president's decision to terminate a discretionary program of a prior president? And in full candor, I'm one of many litigants before the court in one of the cases that was consolidated. And we all agree that a new president can, in fact, end the DACA program, but they must do so in a lawful fashion. And so the second question before the court, of course, is, was the action of the Trump administration in ending the program in the manner it did arbitrary and capricious? And if you had told me when I was in law school that I would be litigating an arbitrary and capricious claim to the Supreme Court, I might not have believed you, because that, of course, is, as we all know, a very low bar in terms of what the federal government would need to show in order to rescind the program. But here, rather than saying, we don't like the DACA program, we do not think it is a good prioritization of immigration resources, we think that there are other things that we should be doing in our discretion, and this is not wise for the country as policy reasons. The Trump administration never says that. And instead they say, wrongly, our hands are tied, we must end this program because it's unlawful. Yet, of course, no court has said whether that program is unlawful. And in fact, there's an attempt to have it both ways, right? The argument that the program must be ended because it's unlawful, but oh, court, you can't review at all our decision to terminate this program. So that's really the legal questions before the Supreme Court. And like many of the cases we'll be discussing today, the human consequences are extremely different. And I do want to highlight that over the course of now nearly 8 years, over 700,000 immigrant young people have entered this program, have gone through, obviously, the screening necessary to have grants underneath this program. And it has, quite frankly, radically changed their lives. It has allowed them to work in their chosen professions, provide for their families in ways they were never able to do, and frankly, to thrive. And so, you know, the rub or the questions before the court have to do with what is required when the federal government decides to pull the carpet out on a program impacting that many people, and what kind, don't they have to show their homework when they do so? The last thing that I would say is there was a remarkable moment, an oral argument, where on rebuttal, I think quite wisely, Solicitor General Francisco gets up and says, to the court, we own this decision. We own the responsibilities of rescinding the DACA program. And what's so interesting about that is, of course, that's the thing that the Trump administration refused to do, to articulate their reasons for ending the program and to take responsibility for this change in young people's lives. And no last-minute rebuttal statement by the federal government's top lawyer can really solve that problem.
And so on the question, you mentioned that you're not challenging the authority of a president to rescind an order of a previous president. They just have to do it in a lawful way. Where did that unlawful action specifically happen, and what could the administration have done, if anything, to rescind it lawfully?
So many things the administration could have done had they chosen to, but the primary one is to articulate their rationales, articulate their policy rationales, and critically to consider the reliance interests of not just the 700,000 young people in the program, and to tell us, why those were properly considered by ending the program, but also the reliance interests of other constituents across the country. And very presciently in oral argument, Justice Breyer, holds up his stack of amicus briefs and says to the government, where is it true? I have all these amicus briefs. And he starts by saying, including from the medical community, and he goes on and gives a list, universities, business, where did you consider how ending this program would impact them? In today's coronavirus world, when we know that over 30,000 DACA recipients are in medical professions, helping us combat coronavirus, this failure to consider the impact of ending the program on our communities and on different constituencies is even more apparent.
I would like to also bring in Pam Karlan to this discussion on DACA. Hi, Pam.
Hi. I want to highlight something that was just said, because I think it's a theme more generally at the court and on a panel sponsored by the Constitutional Accountability Center, talking about accountability as a key to a lot of those issues. And, in some ways, the DACA case mirrors a little bit what happened last year with the census case, because there too, the government claimed we have to ask this question about citizenship in order to enforce the Voting Rights Act. And no one believed that was the real reason. And I think that idea that the administration has to own its position, or that public officials have to be accountable in various ways, is a theme that's running through this term's issues at the court and carried back to last term as well.
Mm-hmm.
So in what way, if at all, can the court take the politics of this in? I mean, in addition to covering the Supreme Court, I cover politics, and it was clear that the decision to rescind DACA was a political one. How does that factor in, especially when it comes to that issue of reliance issue, or like you said, Pam, akin to the census case, that the reason given isn't pretextual?
I mean, I think the court absolutely can take in the politics of the decision making here. And certainly there is evidence in the record, as Pam says, just like in the census case, that the reason articulated for ending the program is not actually the true reason. And that instead, there was an ability or a desire rather, on the part of the Trump administration to be able to terminate the program while blaming the courts for responsibility, and then set the stage for a congressional confrontation over what is necessary for some kind of rescue or replacement immigration legislation. And if that, of course, is the reason for ending a program that impacts over 700,000 young people, then that is something that the Trump administration has to take accountability for, and frankly, political heat for. This is a program that is, in any poll, 80% to 93% popular across both sides of the aisle. And we all know that in the current context, the American populace does not agree about anything at that level. So if you want to end a program that popular, you need to take the accountability and not try to pass that hot potato to the US Supreme Court.
I want to bring Melissa Murray back in as well to make an additional point. Hi, Melissa.
Hi. It's also worth noting, it's not just sort of the political amenability of the program itself, but just this particular political moment and the climate that we're in. And the court allowed, in this particular case, supplemental briefing on DACA recipients who are currently involved in the medical profession fighting COVID right now. So this is a way in which the court is actually bringing to bear the real life consequences of these policy decisions into their own decision making.
Okay, I'm going to put a pin in that discussion there so that we can turn to yet another big case that was just argued by the court remotely. That's the Mazars and associated cases where House members are seeking the financial documents of President Trump. And to discuss that, we're going to bring in Brianne Gorod. Hi, Brianne.
Hi, thank you so much for moderating the conversation today. So, as Kimberly just noted, these cases, and another case that was actually argued on Tuesday as well, are all about efforts to obtain President Trump's financial records. And while there are important differences about these cases, which we can discuss a little bit, at bottom, they're all about the ability of investigative bodies to do their jobs. And that's one of the reasons why these cases are so critically important. What the court decides, how the court decides it, could have major implications, not only for this president and these investigations, but for the ability of these investigative bodies to do their jobs going forward. So the Mazars and Deutsche Bank cases, the first of the cases that were heard on Tuesday, were about congressional efforts to obtain this information, about congressional oversight. 3 different House committees subpoenaed third parties, not the president himself, for financial records from the president related to his businesses and his family. And it's worth pausing to note there's nothing unusual or novel about Congress engaging in investigation, or even engaging in investigation related to the executive branch or to the president. I mean, Congress has been engaging in investigations for as long as there's been a Congress. And it's important to note that it's not just Congress that has said that it has this authority. The Supreme Court has repeatedly recognized the importance of congressional oversight authority, has repeatedly recognized how broad that authority is. As the court has explained, if Congress is going to be able to do its job, if it's going to be able to legislate, it needs information so that it can decide what legislation is appropriate, what legislation should look like. And congressional oversight is how Congress gets that information. And that's exactly what is going on in these cases. I mean, these committees requested this information so they can decide whether new legislation is appropriate on critically important topics, such as presidential conflicts of interest and disclosure laws, such as money laundering, which has major national security implications, and on whether we need new laws to help prevent foreign interference in our elections. So at bottom, this case is about Congress doing its job. And that's true of the other case that the court heard on Tuesday, the Trump v. Vance case. And that case is not about Congress seeking information, but a New York district attorney grand jury subpoena. And here too, the grand jury was doing what grand juries do. It was investigating possible illegality. In that case, the New York grand jury sought the president's tax returns and other financial records, again, not from the president, but from a third party, in connection with its investigation into possible federal campaign finance violations. And again, this is what grand juries do. I mean, the Chief Justice at argument said that the subpoena is the traditional and most effective device that grand juries have typically used to engage in their investigations. And I think a couple of things were particularly striking at the arguments on Tuesday. First is the extent to which this president and this administration's just wholesale resistance, really unprecedented obstruction of oversight efforts was on display. I mean, there have certainly been disputes between the president and between legislatures over oversight questions in the past, but they've generally been over discrete questions. Is this particular document or testimony privileged, for example? What is new here is the just total wholesale resistance to any oversight whatsoever, and the effort to really undermine the legitimacy of congressional oversight. Last year we had the president tweeting repeatedly, claiming that congressional oversight was really presidential harassment. And it was really stunning on Tuesday to hear not only the Department of Justice echoing those presidential tweets, but even justices talking in those ways. Because of course, as I've said, congressional oversight isn't harassment. It's Congress doing its job. It's doing a job that it has done since the beginning, and the Supreme Court has repeatedly recognized is critical, is a critically important part of our nation's system of checks and balances. The other thing that I thought was particularly noteworthy and related is the extent to which this administration is really playing a shell game in its effort to avoid any type of oversight. So, they'll be in one forum and they'll say, well, you can't engage in oversight here. This isn't the proper place to do it. You have to go to this other context or this other situation to engage in oversight. But then you get there and they say too, no, actually, ignore what we said a few minutes ago. You can't engage in oversight here either. So, in these cases, they said in the first arguments, oh, Congress can't seek this information because it's actually engaging in law enforcement. That's wrong. But even putting that aside, that's the argument that they made. And then you get to the second case where they say, oh, actually, law enforcement bodies can't engage in investigation either. What the president's clearly seeking when you put all this together is zero accountability. What he and his lawyers have been asking for is for the court to say essentially that the normal rules don't apply to the president, that the president is above the law. And that is, I think, a result that everyone should find really troubling, regardless of what you think about this president and these particular investigations.
So, Brianne, it's pretty clear that this president, this administration has taken a very broad view about executive authority. What do we know about the court and how it might view the breadth of that authority? And in particular, the two newest justices, Justices Gorsuch and Kavanaugh, are they necessarily votes in favor of the president here?
I mean, I don't think we should assume that at all, in part because of the, the consistent precedent that we have from the court that is really at odds with the arguments that the president's lawyers are making in these cases. I think, thinking about the grand jury case, for example, one relatively recent precedent that got a lot of attention at the argument on Tuesday was Clinton v. Jones. And this is something that even the court's more conservative justices were asking about. That was a case in which the court unanimously allowed a civil lawsuit to go forward against President Clinton. And when you look at all of the reasons that the court gave there for allowing that to go forward, it's clear that the president's arguments here, don't have any merit unless, for some reason the rules apply differently when the president's name is Trump versus the president's name being Clinton. I mean, for example, the court rejected arguments that allowing the suit to go forward prevent the president from doing his job, from fulfilling his responsibilities as president. And of course, here, we're talking about subpoenas that aren't even issued to the president himself. These are issued to a third party. So it's not clear that they would require anything of the president at all. And so when you go through, all of the factors that the court considered in Clinton v. Jones, again, it's very clear that the president's arguments here just, don't hold water.
I want to bring some of the other panelists back in. Karen Tumlin, you have a point on this, please.
Yeah, I really wanted to get Brianne's views on the political question request for briefing. And the reason is, I, as someone who finds myself often litigating against the Trump administration, I'm experiencing this dissonance between their requests for extremely speedy, I would say sometimes out of turn judicial intervention with, for example, the aggressive number of stays from the US Supreme Court that this Solicitor General has sought, versus their aggressive use of arguments around lack of justiciability for the courts and political question doctrine. So wondering how that landed on you and what you make of it here.
Yeah, I mean, it was really interesting to see that order come down from the court requesting that, supplemental briefing so soon before argument, particularly when it was not something that any of the lower courts to consider this issue had suggested was something that would prevent the courts from deciding the cases on the merits, when it was not something that the parties themselves has raised. And, I think the responses that they got back from the parties should not have surprised the justices. All of the parties agreed that the court should decide the case on the merits. And that's, of course, because, this is not a political question. It is the type of question that the courts routinely decide and are well suited to decide. And, it's worth emphasizing, too, that, for the court to take that kind of punt here might have handed the House a short-term victory in the sense that it would have allowed the third parties to comply with the subpoenas. But it could have, really, really significant and troubling consequences for congressional oversight efforts going forward if, the executive branch refused to comply with congressional subpoena. So, I was relieved at argument to see that it did not seem like it was getting much traction. I think Justice Gorsuch asked one question about it, but it didn't seem like something that the court was likely to pursue.
Melissa, I think you also had a point here. Come on in.
Well, I just wanted to go back to the excellent point that Pam made earlier about accountability. And, we've talked about this issue from the perspective of keeping the president accountable. But at oral argument on Tuesday, the court seemed more interested in the question of how Congress would be kept accountable. And, I think we saw that the president's framing of oversight as quote unquote harassment was something that the court was really preoccupied with, even liberal members of the court. I think Justice Breyer had one of the most evocative statements at oral argument where he compared the idea of Congress harassing the president to Joe McCarthy bedeviling FDR and Harry Truman. So to that extent, the accountability goes both ways here, which is perhaps more unexpected.
And I want to take it back to Brianne so that she can talk about another case on the docket, the challenge to the constitutionality of the Consumer Financial Protection Bureau. Go ahead.
Great. Well, this is another really important case, not only because of its potential implications for the Consumer Financial Protection Bureau, the CFPB, but potentially for independent agencies more broadly. So the question the court's considering in the case is whether it is constitutional for the CFPB to to be headed by a single director who can be removed by the president only for cause, for inefficiency, neglect of duty, or malfeasance in office. Those are the standards laid out in the statute. And it's worth pausing for a minute to think about why the Bureau is structured in the way that it is. After the 2008 financial crisis, Congress spent months and months and months studying the roots of the crisis and trying to figure out what could be done to prevent similar crises from happening in the future. And one thing that Congress decided needed to be done was we needed an agency whose sole mission was protecting American consumers from reckless financial products. And Congress concluded that that agency would be best able to do its job if it were headed by a single director and one who enjoyed some degree of independence from the president. That was the policy judgment that Congress made in determining how to set up the Bureau. And, the Bureau has been, since its creation roughly a decade ago, incredibly successful. But what we've seen is that despite those successes, or possibly because of them, there have been concerted efforts to undermine the CFPB, to get rid of it and prevent it from doing its work. And we've seen those both in Congress and in the courts. And I think one of the more interesting aspects of this story is the extent to which the arguments being made by CFPB opponents in the courts really mirror to a surprising degree the arguments that are being made outside of the courts. They're dressed up a little differently, of course, and they're put in the language of constitutional discourse. But the arguments, for the most part, have really not been about constitutional text or constitutional history. And I think the reason for that is simple. When you look at constitutional text and constitutional history, it's clear that Congress had the right to structure the Bureau in the way that it did. There's no explicit provision in the Constitution that says the president has to be able to fire all executive branch officials at will. And when you look at the history, it's clear that at the founding, the framers gave Congress considerable discretion to structure agencies in the way that they thought would enable them to best do their jobs. And that's something that the Supreme Court itself has recognized over and over and over again, including in a relatively recent decision written by the Chief Justice. We've obviously talked about precedent already with June Medical Services and with the Mazars and Vance cases. And here again, it's going to be really interesting to see how the court deals with these precedents. At the argument, it didn't seem like there was an appetite, at least from a majority of the justices, to overrule these existing precedents that uphold the constitutionality of independent agencies. And I think, for a good reason. I think, even for the court's conservatives who may not have overall a favorable view of the administrative state, I think they have to realize just what a big deal it would be and how destabilizing it would be to say that independent agencies are unconstitutional. I mean, just to think about one example, does anyone, think that it is unconstitutional for members of the Federal Reserve to have some degree of independence from the president? You just think about what it would be like if they didn't, and the kinds of political manipulation that would allow. And so, because I think the justices don't want to overrule those, those who might have been somewhat inclined to rule against the CFPB were really wrestling with whether there was a way to distinguish the Bureau from other independent agencies. And the challenge, I think, is that it's really very difficult to do that. One thing the CFPB's opponents have said is, well, the CFPB is headed by a single director rather than a multi-member commission. But of course, from a constitutional perspective, the question is, does the president have sufficient control that he can ensure that the laws are faithfully executed? And when you're talking about accountability, a single director is actually more accountable than members of a multi-member commission who serve staggered terms. At argument, the Chief Justice, asked a number of questions about the budgetary independence of the CFPB. But that too doesn't distinguish it, because that's a feature that's shared by many independent financial regulators. So, here too, this is a case that I think is incredibly important, both because the CFPB is at stake and because what the court says and how the court says it and what separate opinions say may give us some indication of where the court is heading on this larger issue.
I want to ask a similar question that I asked in another case, which is the addition of Justices Gorsuch and Kavanaugh on this issue. Yet another struggle of separation of powers here. How do you see them playing in? Were there any clues from the argument there?
Yeah, I mean, these are justices who, in their careers in the lower courts, definitely expressed hostility to the administrative state. Justice Kavanaugh, we know exactly what he thinks about this issue because he wrote an opinion when he was on the DC circuit saying that the CFPB its leadership structure was unconstitutional. That decision was later overruled or reversed by the full DC Circuit sitting en banc. And Justice Gorsuch, while he hadn't spoken to this particular issue, has taken aim at other fundamental parts of the administrative state, like Chevron deference, the idea that courts will defer to an agency's reasonable interpretation of an ambiguous statute. So they are definitely ones to watch. And I'll say, I think when this opinion comes out, it'll be important to see not only what is in the court's majority opinion, but what is in some of the separate writings, if there are any, as well. We've talked already about the court sometimes taking an incrementalist approach to chipping away at precedents. That's something we've seen not only in the abortion context, but in other court contexts as well, like campaign finance, issues involving labor unions. And I think it's something to definitely be on the watch for when it comes to administrative state issues as well.
All right. Well, thank you so much for taking us through that case. And next, I want to, that brings us to the Harris v. EEOC case, the Title VII challenge, which was argued by Pamela Karlan. And luckily, she's on our panel to talk about it. Hi, Pam.
Hi. Actually, I didn't argue the Harris.
Oh, you didn't argue that one. Sorry.
I argued the Bostock and
that's right.
cases. So
I can't remember anything anymore. I call it
No.
COVID and COVID amnesia.
It's been a while. These cases were argued the second day of the term, and so I do want to disclose that I argued one of the two cases, but not the Harris case.
Yes.
Title VII of the Civil Rights Act of 1964 prohibits employers from firing somebody because of that individual's sex. And the question at issue in Harris Funeral Homes is, what does that mean? What does that phrase "because of sex" mean? Amy Stevens, who unfortunately died earlier this week, was a funeral director at the Harris Funeral Homes. And one day she wrote a letter to her coworkers and her employer announcing that she was going to now live as the woman she had always felt herself to be. And Harris Funeral Homes fired her on the grounds that she really was a man. Because at birth, she had been assigned the sex of male on her birth certificate. She brought suit claiming that this was sex discrimination, and the Sixth Circuit ruled in her favor. Interestingly, at the Sixth Circuit, the EEOC, the Equal Employment Opportunity Commission, which is a federal agency, was representing her and arguing on her side. But it became clear that the Trump administration was going to change positions on this, so she intervened in the case. And so although the case is called Harris Funeral Homes against EEOC, at this point it really is Harris Funeral Homes and the EEOC against Amy Stevens. And so the question is, what does it mean to talk about because of sex? What do those words mean in the statute? And one of the things to keep in mind is that the Supreme Court unanimously in 1998 in the Untitled against Sundowner case, in an opinion written by Justice Scalia, said that statutory prohibitions, like the sex discrimination provision here, often go beyond the principal evil to reasonably comparable evils. And it is ultimately the provisions of the law rather than the principal concerns of our legislators by which we're governed. And this case puts that into stark contrast. The argument on Harris Funeral Homes side, I think it's fair to say, really is that when Congress enacted the Civil Rights Act of 1964, the legislators were not thinking about protecting transgender individuals from being discriminated against because of their gender identity. And that if Congress wanted to talk about gender identity, it should have used that phrase. Now, in 1964, that phrase wasn't actually in existence yet. But leaving that aside, their argument is Congress didn't mean to protect people like Amy Stevens from employment discrimination. The argument on Ms. Stevens' side is read the text, that the reason she was fired, and the funeral home admits this, is because on her birth certificate it said she was a man, and she claims to be a woman. And the lawyers for Ms. Stevens say that's sex discrimination in its most basic sense, which is what sex was put on your birth certificate. They also raise two other arguments. One of them builds on the Supreme Court's decisions in cases like Price Waterhouse against Hopkins, which say you can't fire somebody or deny somebody job opportunities based on a sex-based stereotype, that women should act one way and men should act another. And they claim that it is a stereotype that people who are assigned male at birth should present as men rather than as women, because while that stereotype is true for most people, that is the overwhelming number of people identify with the sex that was placed on their birth certificate at birth. Miss Stevens doesn't, and it's a stereotype to force her to comply with that. And their third argument draws an analogy to the fact that Title VII also prohibits discrimination on the basis of religion. And they say, you clearly can't fire somebody who converts to a religion and say, well, only people who belong to that religion since birth are members of that religion. And the same thing is true here with regard to sex. Amy Stevens identifies as a woman, and the fact that at one point in her life somebody else identified her as a man doesn't allow for discrimination. So that's the issue in the Harris Funeral Homes case. And I'll just say that it's tied up with the issue in the Zarda and Bostock cases, which is whether Title VII prohibits discrimination against for someone who's gay based on that also being sex discrimination. I'll just end with one point about the oral arguments, which is the oral arguments in these cases almost in a sense presaged what Elizabeth mentioned earlier, which is the flush heard around the world, because the Supreme Court asked an amazing number of questions about what are the implications for bathrooms of ruling for the plaintiffs in these two cases. So these are the oldest cases still on the docket, and we're expecting a decision sometime relatively soon.
Now, Pam, you laid out a lot of the arguments that was made here. From the argument, from the oral argument, which do you think had the best chance of catching the ear of the justices? How might they rule here? Might it be on the stereotype issue? Where do you think it's going?
So it's a little hard to say. I think that as I suggested at the beginning, the real rub here is that the words of the statute and the court's prior precedents really do support the plaintiff's arguments. And as Justice Gorsuch said at oral argument, the words seem to support the plaintiffs, but doesn't that seem very disruptive as a social matter, as a societal matter? And so I think that, if the court sticks to the text, they should rule for the plaintiffs. And if they don't, it'll be a really telling illustration of just how far the justices who claim to be textualists are willing to go. We saw that again, actually, this past week in a case that we're not going to discuss at length, but it's a case about whether large parts of Oklahoma remain part of the Creek Reservation. And there, too, Justice Gorsuch asked a question that said, how should the court really be thinking about things when the text goes one way, but we think the consequences might count against that? And we saw that again in the faithless elector case. So it's a theme across a lot of this term.
I want to bring Karen back in to the discussion as well. Hi, Karen.
Hi, thank you. I wanted to bring up on people's minds and probably in their hearts the letter that Pam referenced at the beginning. I will admit that when I first started reading about this case, I wrote down in my notebook the words that Amy Stevens wrote her co-workers. And she wrote, I have known many of you for some time now. The first step I must take is to live and work full-time as a woman. I will return to work as my true self in appropriate business attire. And I was so moved by those words as a human, as a parent. That's what I want for myself. It's what I want for my children. And every time I've interacted with this case, with predictions of this case, I've been really grounded and moved by the words of the plaintiff in terms of the basic dignity that I think Title VII recognizes for all of us.
Thank you for that, Karen. When we have cases like this, so often the court does talk about things like dignity, including in the same-sex marriage cases. But often, other times, the court will say, it's up to Congress. If Congress wants to outlaw discrimination based on gender identity, then they would say so in a statute. How likely is that to be an outcome here? And what might be the practical issues of such a ruling?
Well, you know, Congress did speak to the issue as the position that we as the plaintiffs take, which is they said you can't discriminate against people on the basis of sex. And just as discriminating against somebody who's in an interracial marriage is discrimination on the basis of race, so too discriminating against somebody who's in a same-sex relationship is discrimination on the basis of sex. And, you know, if Congress didn't like the decisions that have been issued by the two en banc courts, the Seventh Circuit and the Second Circuit recently, then Congress could amend the statute. But I don't think they're going to, because most Americans do believe, regardless of what their private beliefs about private sexual behavior are, they don't believe that people should be fired from their jobs for being gay or for being transgender.
Back in as we prepare to take questions from the press and the audience. Before we do, I just wanted to give Brianne a chance to ask Pamela a question.
Well, yeah, I was just curious, Pam, if you're surprised by how long we've been waiting for a decision. As you mentioned, this is one of the first cases that was argued this term. It's one of the longest outstanding. Did you expect to have a decision by now?
I didn't expect to have a decision by now. As you probably know, the last three big gay rights cases at the Supreme Court were all announced on June 26th. So if it goes past June 26th, I might be surprised. I mean, one of the things that makes this a little more complicated than it often is normally the court finishes its oral argument calendar, the arguments in late April, and then they have 2 months to write the decisions. This time around, they didn't have arguments in the March or April sitting, so they had more time to work on the earlier cases. But now they've had a May sitting, and so it's really hard to know how all of that will play out.
Definitely a very different rhythm.
Yeah, the rhythm's got to be totally different now than it would have been when they were on their usual schedule. So I'm not surprised that it's taken longer to decide this than some of the other cases from October.
Okay, and I want to, as I said, open it up for questions. This event is usually held at the National Press Club, and in that interest, we want to prioritize questions from the press. So we have a question for the panel from Greg Storr from Bloomberg. The question is, Karen and the others, could you talk about the various ways the court could decide the DACA case and how those different ways could affect how quickly people start losing their DACA status?
Sure. Thanks so much, Greg, for the question. I'll start, of course, with the negative since you're asking about losing of status. So I believe that it would be remarkable in a loss scenario if the court either instructed or the implications of that ruling were that DACA grants, even those that have not yet expired for work authorization and protection from removal, were clawed back. I think in order for that to occur, the court would have to go on and to rule that DACA was not lawful originally. And that's not a ruling that the court needs to make. I think what's more likely in a loss scenario is, not every DACA grant was issued on the same day. They're phased in over time. But what we do know is, so for example, if there's a loss between now and the November presidential election, 1 in 5, or almost 120,000 DACA recipients will lose their work authorization and protection. The reason I benchmark that date, of course, is that a new president might well want DACA and want to rescind on their first day in office the president's policy eliminating it. So that's what we're facing for a loss. I think it's not, if there's a loss, it's not likely that it would be all at once. Instead, it would phase over time, that 1 in 5 DACA recipients before the election. And then obviously in a win scenario, I want to remind folks that right now we have the situation where only DACA renewals have been allowed. But in a win scenario where the court upholds lower court rulings that the rescission of DACA was arbitrary and capricious, we could see first-time applications for DACA.
I want to bring Pam into this discussion as well. Pam, I believe you have a question.
Yeah, my question is, before this administration tried to get rid of DACA, Texas was trying to get rid of DACA too. And I wonder whether you think that lawsuit will spring back into effect if the court doesn't rule in the administration's favor here.
I think that's of course a possibility. This is when I confess I was born and raised in Texas. I think, however, I want to remind that the state of Mississippi tried to file a legal challenge to the lawfulness of DACA that was thrown out of court for lack of standing, including at the Fifth Circuit Court of Appeals, the very court where the Texas lawsuits had gone up to previously. So yes, I think it's possible. The leadership in the state of Texas, and the Attorney General specifically, have made it clear that they want to continue to challenge the legality of the DACA program, despite its benefits to the great state of Texas. But I do think they'd have to initiate a new action, and they'll be swimming upstream against that. It's called the Crane case precedent.
And now I want to go to another question from the press about the new world we are finding ourselves in, covering the court. It's from Tony Morrow from the National Law Journal. And he asked, do you think the court will return to its long-standing oral argument format in the fall, or will certain aspects of the teleconference format be worked in to accommodate more uninterrupted answers from counsel and more questions from Justice Thomas? What do you think about that? How about Brianne?
Sure. Well, I think I guess that it's unlikely that once we return to in-person sittings, that the court keeps with this calling on the justices seriatim. But I do think that it's very likely that the court continues this practice of live streaming the audio. I think it's going to be very difficult to go back now that the court has done this and has seen, I think, how well it works and how good it is for the public to get more of a window into the court's processes. Elizabeth talked at the opening about trying to find silver linings. And I think the fact that the pandemic pushed the court to take this step, which of course many, courts of appeals have already taken, was a very good thing. And, one thing that we have seen is that there hasn't been the kinds of things that the court's justices have expressed concerns about in the past, grandstanding by justices or by attorneys. What we saw were really good and thoughtful questions and answers and discussions in all of the cases that the court has heard over the last couple of weeks. So I think that is very likely to continue, and that is a very good thing.
And I want to try to get another question in from the press before we run out of time, and that was from Adam Liptak of the New York Times. He asked, do you expect separate opinions in the two Title VII cases and in the two Trump subpoena cases?
So I can speak to the Trump subpoena cases, and I'll let Pam discuss the Title VII cases. I think we will see, obviously one opinion for the consolidated congressional oversight cases, Mazars and Deutsche Bank, and then a separate opinion in Vance. Just because, while, as I said, at bottom they raise similar questions about the abilities of these investigative bodies to do their jobs, the legal questions, as you know, are quite different about, congressional oversight and its breadth and how it applies in the context of requests relating to the president in the case of Mazars and Deutsche Bank, and this question about presidential immunity in the context of criminal investigation and subpoenas as part of a criminal investigation in Vance. So I strongly suspect we will see two different opinions addressing those distinct legal questions.
I'd like to bring in also Pam and Melissa to talk about that as well.
So in thinking about, is the court going to issue two opinions or one in the Title VII cases, I think it may depend on what rationale the court goes off on, because there's an overlap. Each of the cases offered three rationales for why Title VII should cover the discrimination at issue. Two of those rationales overlap between the cases. The rationale that's about the text standing alone, and a rationale about sex-based stereotypes. But each of the cases also offered a theory that wasn't available in the other case. In the transgender discrimination case, it was a question about whether or not an analogy to religious conversions and the fact that converts are protected under Title VII would allow a ruling for the plaintiff. And in the sexual orientation cases, the analogy was to Loving against Virginia, and the fact that discrimination on the basis of interracial marriage, even if both races are treated treated the same, is sex discrimination. So it may depend on how many of those rationales the court feels the need to address, whether it will decide the cases in one opinion or two.
And I want to bring Melissa in. We're almost out of time, but I want you to get the last word.
I'll be brief. Back to Trump versus Mazars and Trump versus Vance. It's entirely likely, I think, that there will be two opinions, but I think the practical import will be the same. I think it's likely that the court may allow the disclosures to the grand jury and may come up with some higher standard for congressional subpoenas and then kick it back to the lower courts to decide if that standard's been met. But in either case, if that's how it works out, the financial records are sort of still under wraps during the course of the presidential election, which avoids the whole question of whether the court will have a say in whether some vital information will be released to the public in time for the election.
Okay, well, I just want to make a couple notes. If the members of the press had more questions, you will, if you reach out via email, we will try to get those answered for you. Also, this video will be available after this broadcast if anyone is hoping to find that as well. I would like to thank all of the panelists for this discussion on this term's big cases, and also a very special thank you to Elizabeth. And to everyone at CAC for letting me be a part of this, and thank all of our attendees for joining. Thank you so much. Have a great day.